Good afternoon, everyone. This is the Docketwise webinar on running a humanitarian immigration practice. I'm James Pittman, co-founder at Docketwise. I have with me my guest, who's Chelsea Zuzindlak from the law firm of Zuzindlak and Boxwala in Detroit area, Michigan. And I'm going to introduce Chelsea and let her tell you a little bit about her background. We're going to be talking today about some of the more nuts and bolts aspects of running a humanitarian immigration practice, concentrating on types of cases such as VAWA, such as asylum, such as U visa, maybe touch on T visa and some of the other humanitarian types of cases, and what is different about handling these types of cases as a private attorney versus handling more, your sort of more general immigration practice. What do you need to pay attention to? How do you need to organize your practice? And what are the special skills that are needed for these particular types of cases? Well, let me introduce Chelsea. Chelsea, thanks again for joining me on this webinar. Can you please tell us a little bit about yourself?
My name is Chelsea. I've been practicing for almost 10 years. I started practicing in the honors program of the Department of Justice, where I worked as an attorney advisor for 4 immigration judges at the Detroit Immigration Court. An attorney advisor actually wrote the decisions for those opinions that the judges needed to draft rather than dictate on the bench. And after that 2-year program, I went to private practice in what people call big law in downtown Detroit. And I did employment-based immigration law there for about a year. And for personal life-related reasons, I left big law and decided that having a smaller to mid-sized firm, having the control over my practice was what was right for me. And that's where I've been for 5 or 6 years at my firm, Boxwala Zuzindlak PLLC.
Mm-hmm. And so, the concentration on the humanitarian types of cases, I know that's something you prefer. Is it, do you not accept other types of cases? Do you accept all types of cases, but prefer those types of cases? How do you envision keeping the humanitarian focus?
Yep. So from the get-go, when we started the practice, we accepted all kinds of cases. And over time, we realized, and when I say we, I'm speaking about myself and my partner, Zainab, that we decided that we as people prefer the humanitarian type of cases. And it might have to do with our upbringing, or I studied anthropology actually in school, and that might be part of it. Also, we were both partners in the Asylum clinic at our law school, so that was our educational foundation. And that's how we learned to interact with immigrants before we started our practice. And then, of course, in the immigration court, the judges were primarily writing extensive written decisions on the humanitarian types of cases. So I really was kind of funneled into this probably when you look at my history. But we did feel some pressure, maybe self-pressure, to just take on all the types of cases and learn everything in immigration. And eventually, about a year and a half ago, we thought, we're going to start winding down the employment stuff. We don't enjoy it as much. Then we put a full stop to it. Recently, we have actually hired someone to continue our legacy of doing all immigration, but he will handle the employment-based stuff. We have the knowledge to do it. We can manage these cases, but we don't prefer to be close to them. I don't prefer to be close to them. I like to have my hands in the humanitarian cases. Okay,
and of those humanitarian cases, what are the main types of cases that you're handling nowadays?
The main ones we do are standalone VAWAs or VAWA plus adjustment of status cases affirmatively with USCIS, asylum, and U visas. And then there's also it's just a standalone application called an I-765B, and that is for non-immigrant victims of domestic violence. They can get an employment authorization, and we tend to do those.
Now, how does that, and I'm jumping ahead a little bit, but I'm
It's
just
okay.
curious, how is that different from going through the regular VAWA process? If you're filing that I-7, what did you call it, I-765, which one?
I-765V.
V, okay. And how is that different from going through the standard VAWA process?
So the individuals that qualify for that work card aren't VAWA eligible because they are only for non-immigrants such as an H4, L2, or E2 who are married to the principal's H1B, LE. They would never become, even if they're victims of abuse, but their spouses are not LPRs or citizens.
Got it. Is that available to someone who's undocumented?
No, you have to be admitted in
Legal status.
one of those dependent non-immigrant categories.
Okay, I see.
And you have to prove your admission, and you also have to prove that the principal is in status as well, at least initially.
Mm-hmm. Okay. Well, that's, hey, that is still a very important benefit, which affects a lot of people, because I would imagine that people who are spouses and partners who are in the dependent status can feel trapped if their immigration status depends on the principal's immigration status. And that feeling of that legal dependency by virtue of the immigration tie to the principal applicant is what places them in a vulnerable position. So this benefit allows them the right to work in the United States independently of the principal's immigration status, and I guess is very liberating in trying to get them out of an abusive situation. Is that your understanding of what the purpose of the program
is? No,
100%.
That's the policy behind it. And you mentioned VAWA. VAWA, the actual legislation of VAWA authorized this. So some people might say, oh, the VAWA EAD. It is an EAD authorized by VAWA. What I also find, yes, of course, it's liberating. I mean, they need to have an independent status. And actually, some of these spouses were not working because their spouse prevented them from getting their EAD that they would have otherwise been able to get as an H4, L2, or E2 holder, and their spouse didn't allow them to apply for the EAD. But whether or not they actually use that EAD is one thing. I find that it is something mentally, psychologically, emotionally, something that they immediately, when they're getting out of that abusive situation and they're coming to see me, this is a process that they're finally doing for themselves. So it's like very transformative for them individually. Like it gives them hope. It makes them feel I have a safe place. My attorney is a safe place I can go to, and it's like, it's just the process, because it takes about a month to prepare the application or a couple of weeks to get it out, and then you're working very closely with the client in a very critical time of need for them. So it is a kind of a unique service in that respect. Their life is a mess, and they're needing to get to safety, and they're needing to get to an independent place in their life.
If they, once they apply for that, if they're granted, then are they, is their ability to renew it now independent of the principal status?
No, it is not. It is a 2-year work card, and they are eligible to renew it one time.
One time.
And I have not done any renewals because often again, this is just like specific demographics that I deal with. Maybe during the 2-year time, the person finally, when they feel settled, they may return to their home country. Or I've had clients actually get an H1B. Okay. Yeah, and not need to. It's transitional. The policy behind it is transitional. If someone's going through a divorce, and you have children, like, it doesn't give you legal status.
Their underlying status remains what it was. It's just the right.
And expires when it expires.
Right.
You had H4, for a couple months when you entered. It's going to expire, and it won't be extended just because you got the EAD. But the EAD will toll any unlawful presence.
Okay, well, that's good. That's good. Let's talk a little bit about your clientele. So did you kind of just sort of happen into your clientele, or did you set out to, and who are your clientele? Are they coming from a particular part of the world? I know we talked a little bit about this in the green room before we started, but let's tell our audience who your clientele is, and is that something that you set out to attract a specific clientele, or it just sort of happened that way?
I personally don't have any fluency in any other language in the world. I'm only a native English speaker. So from the get-go, I knew that I personally would be limited in the types of populations that I can comfortably interact with. And by comfortably, I mean that I am comfortable with the level and integrity of professional services that I can render them. So by way of getting started, and my partner, she is of India, from Indian descent, and she's multilingual. So kind of her being that, and then I also had connections with the Indian American community, professional ties. And so we just kind of naturally, organically, we didn't seek out this demographic, but we generally service Indian immigrants in the Metro Detroit area. And then that's also kind of Asian, Burma, China, Thailand, kind of just branched out into different Asian communities in the area. And particularly with the Indian population, they speak English. It's one of their primary languages back home. So it's been very easy to build rapport with them. I'm also, personally, I'm actually a Hindu, and that's that I'm able to relate to the group, my clients.
Great. Now, so so it's a mostly English speaking. Well, let's get on to the topic of asylum now. Asylum's one of your main area, affirmative asylum, and do you make a specific decision that you're not going to take asylum claims in removal proceedings? Are you still doing removal proceedings, or you're not doing them, or?
Yeah. So if any of my affirmative cases were to be referred to immigration court, I would 100% be available to the client if I feel that I can represent them in court. I'll give you an example where I declined. I've had a case referred from a client from Iraq, and while we conversed very well in English, I had never directly represented like his wife and children during the affirmative process. And now those derivatives were going to be like, they were going to have to testify in court as witnesses. They would have to. And because they weren't strong English speakers, I referred this family over to an Arabic speaking attorney who I knew. I want the clients to feel comfortable preparing for their cases and not just stick with me because they do like me or trust me. And sometimes it's a difficult decision for the client to make, but I actually encourage my clients, if we're approaching a next step of their process where I know there is somebody that can do better than me, I want them to go, to take the leap and go with that new person. And I'll do whatever I can to transfer the case file electronically, physically, get that new attorney up to speed. One thing I think we do well here in our practice is we know what we do well and the best, and we know where that line ends, or like in the timeline or life of a case where it might end. And I lift up my colleagues in the field, and like I'm not like hoarding the clientele in my firm that I want all the clientele in the world, I want my clients to win their cases. And so if I can't provide a service that I think I'm going to do the absolute best, then I want to hand them over to someone who will.
Absolutely. All right, let's go a little bit into the nuts and bolts. So let's talk about drafting the narrative affidavit for asylum cases. How do you approach this very essential task? I mean, the I-589 form itself asks you questions about your past persecution or fear of persecution, and some other questions asking for explanatory answers that are criteria for eligibility. But we all know that a well-written affidavit by the asylum applicant is essential to succeeding in your case. So let's talk about that. What's your theory behind drafting the affidavit?
My goodness. It's a very everyone has a different approach, right?
Sure.
So people who are coming to me and I'm their first attorney, I usually ask them to start by writing something themselves. And then we have 2 or 3 in-person meetings where we have an oral interview and I take notes and I take their initial draft and I draft it from these interviews and provide it to them, and then maybe we'll go through 2 or 3 drafts electronically for them to confirm or reaffirm what has been written, make changes as needed, and that's how we'll get to finalize it. It's a little bit more difficult when a case is referred to me after the person has already written their personal statement. And I'm at the point right now where I actually need to exercise a little restraint because the way that we do things is very detail oriented. It is extensive with the in-person interviews, but I don't want to midstream, if I'm getting somebody who's referred to me, who's already written a draft, and so much time has passed, right? When someone files an asylum application and then years go by, the memory is so much stronger if a client is coming in, like flying in from their home country, and within a month or 2, we're meeting and we're doing this drafting process. It's different when somebody has already kind of written a statement and several years have already gone by. I feel I need to exercise restraint and perhaps not redraft the statement, leave the statement as is, okay, and move toward preparing them for testimony, the testimony part, whether it be the in-person interview down the road or in removal proceedings hearing.
Do you find people coming to you who have already filed an I-589 and
Yes.
then, okay, and then sometimes I'm sure many of us have seen this. People come in, they filed an I-589, either something that they wrote themselves or they've gotten help from a friend or someone in the community or so, and they filed an I-589 and it's not what a qualified immigration lawyer would have drafted. It's not, they're usually, many times they can be very sparse on details and can be other major problems with them. So what would you do at that point? You know, if someone's come in and you see that there's a 589 that's already been lodged and it is very lacking, I mean, what do you do next?
In that case, because they're not referred from another attorney, they've not been represented before, they don't have an attorney's eyes over the statement that they prepared, I would work with them to draft a new statement. I mean, they might not have even submitted a statement, or they'd be relying on their explanations in the I-589 form itself, but probably not do as much of a detailed job as I would do if someone came in never having filed something. And really, I always go back to the refugee definition. Like, we think that we always have these things memorized, right? But I will always go back and read the refugee definition to ground myself and say, okay, what are the elements here? And that will be the framework. Let's, at the most basic level, make sure that your statement covers the refugee definition. And we don't need to go into so much detail that your mind and memory is stretched, but let's just get a foundation prepared that meets this definition. I would say that's the ultimate goal in the situation.
All right, and then a very important aspect of preparing an asylum case is obtaining documents from the client's home country. And that can often be one of the most challenging aspects of the case, I found. How do you see your role in assisting the client with putting together the documentary evidence that you're going to need? I mean, how proactive of a role do you take, and what are some of the challenges that you've seen? Maybe give us a couple of examples of the types of documents they need to collect and how that process goes.
I almost feel like I have more questions for you about the same thing, because I have this particular challenge right now in a case that I have. Chinese religious persecution claim. The client is telling me, and I wholly believe him, that the documents are not going to make it out of China. It is not safe for his family members who are witnesses to mail me anything. And now we're getting into an authentication issue. So I'm comfortable receiving something via email, but is the court going to feel that this is authenticated or credible documentary evidence?
Right.
Right. So I'm only going to probe. There's only so many times that I can state it or probe the client or push the client. And ultimately it is their case. Okay. So I'm at a position in this type of case where I've stated it 2 or 3 times that we should get some statements from the witnesses in China. There were people, eyewitnesses to the persecution that my client faced. And that is written in his statement that he's already prepared. And I would, if he agrees that his spouse could write a statement, what I would probably do is draft something very, again, just very basic, foundational with regard to the story in English that they can then work with the family member in China for them to write in Chinese. The family members in China are not English speakers. What do you think, James?
That is probably going to be I mean, my take is
I don't speak Chinese.
Yeah, that's probably going to be the best thing that you can do. I mean, have them write the statement in Chinese. They can dictate it to either dictate it themselves or dictate it to a sympathetic party, have them write it in Chinese. I don't know how you're going to have it sort of signed and notarized. I don't know what the procedures for having things notarized in China are. And even having something, if there is a notarization procedure, they would probably be afraid to do that, given that, given the level, from what I understand, the level of surveillance that people are under in China. So I don't know if they would be.
I think they would only be comfortable sending it to me via email.
Mm-hmm.
And if they did that, I think that there's not much more that I can do there in that situation except for elicit testimony from my client about as to the reasons why that person cannot produce a written statement, like hard copy, mailed, raised seal, notarized statement.
Right. Yeah, it may be. It's maybe impossible to get. And then I would kind of supplement the record with proof of, additional proof of the persecution of any persecution of family members that you can sort of point out evidence thereof of why the family members would be afraid to mail something to you. But maybe I mean, there are private couriers. Maybe they could use a private courier. Would they be afraid to do that, like DHL or something like that? Put it in a DHL envelope and send it?
Oh, we'll explore those options. That's the preferred way.
Because I know if you send it through the regular postal system, I can see them being afraid of that. But maybe through a private courier, DHL, maybe they wouldn't have anything to fear doing it that way. That's just a thought. But yeah, supplement the record with evidence of the circumstances of why you cannot produce an original statement, and that may be the best that you can do there. I don't see how else you're going to do that. But the applicant's own testimony is sufficient if it's credible. Of course, it's always best to have as much supporting evidence as you can get. The advantage you have, I'm just thinking out loud, the advantage you have is it's China, and there's so much information available about the different forms of persecution that take place in China. So there's not a shortage of credible sources to cite. But it's challenging. Okay, let's leave that one and talk about. Let me talk about this now. We're talking about asylum, and we were talking about before a few minutes ago. We were talking about VAWA. Do you ever handle asylum claims or formulate asylum claims based on domestic violence for people that would not be VAWA eligible?
I do not.
Okay.
Have not. Well, I don't speak Spanish. In terms of the case law, right? The case law surrounding domestic violence or these types of claims have historically been coming out of Central and South America. It doesn't mean that they don't come from elsewhere. They absolutely have. So, for example, I've had clients that could have qualified for like a gender-based or domestic violence-based asylum claim, but they also qualified for VAWA, so we did VAWA. Like we wouldn't do asylum. So I haven't had I haven't been confronted with people wanting to do those claims. I know there's a plethora of them, thousands of them. They're not. It's not something that has like really come under our umbrella here to do that. We've explored gender-based or domestic violence-based claims for citizens of India. However, a U visa was more fitting to do. So, do you know what I'm saying?
Absolutely, sure.
Yeah.
And
we have actually found ways to like not to do asylum for those types of claims.
No, there's a lot to be said for that. I mean, that's something which I think you need to spend time thinking about, because there's an interplay between these different humanitarian forms of relief. I mean, right? Some people even, I mean, you need to keep these clear in your minds, but at the same time, these things sort of at the extremes, they sort of shade into each other. You know, humanitarian forms of relief, asylum, VAWA, T visa, U visa, special rule cancellation. These are all different things, but a person can be eligible. You might be able to have claims for eligibility under multiple of them at the same time, and then it becomes a choice of which form of relief to seek. I mean, VAWA has the huge advantage that the person would become a permanent resident if their VAWA claim is. T visa and U visa are non-immigrant visas, but at the same time, if your choice is between asylum and T visa or U visa, you need to keep in mind that asylum, especially if the person is out of status, is going to be the fast track to getting into removal. So that needs to be a consideration. And asylum
is like, it comes up very. I mean, asylum at first blush appears to be the best option, especially with being able to apply for the EAD so quickly and getting that, whereas like U visa, the EADs were backlogged, but now, I mean, now we're lucky with the policy change. Now we're, it's a more attractive option now for clients. But yeah, I think your point about asylum is the fast track to go to deportation proceedings if it doesn't pan out at the affirmative level, or not just that, but you have to remember to tell your clients when you're going through these options. Like for the Indian client who we chose to do U visa instead, she said, so I can never go see my mom again. No, you cannot return to your home country if you do win asylum, or during this process of trying to do asylum. U visa, you can travel, you can go see your mom. Of course, there are other considerations there, but it can be very devastating to someone to think that they will never, and maybe until citizenship, but never be allowed to see their parents or a loved one or the one person who is supportive in their home country to them. So we can't forget to go through all those finer points when going through the options with the clients.
That's exactly right. And I recall a circumstance of someone many years ago who we successfully obtained a T visa, trafficking visa. And this looked at first glance like a domestic violence case, but it actually, when you went deeply, it was a situation of a forced marriage. Forced marriage is a kind of whole other situation where the person has been forced into the marriage against, they didn't have the consent to whom they married, or didn't consent to remaining in the marriage. And it happened to be a particular situation where the person had been forced into a marriage in their home country and brought to the United States as in the marriage, and essentially made into was kind of, I mean, I hate to, demoted from being a spouse to being a domestic worker. So this woman's husband was basically forcing her to work for him, and we actually framed it as a trafficking case. Trafficking, right? It's either there's if the person is over 18, there's either fraud, coercion, force, and they are being forced either into to perform a commercial sex act or involuntary servitude, right? So these are, it's either labor trafficking or sex trafficking, right? Those are the two main forms of trafficking. If the victim is under 18, you don't need to prove coercion or fraud. It's enough that they have been forced into the situation. This situation, even though the applicant was married to the person that was abusing them, the particularities of this particular circumstance, we were able to demonstrate and prove that it was a forced marriage. The person had been brought into the United States to be made into a situation of involuntary servitude, and we were successfully able to get a T visa. Now, the advantage of doing the T visa in that situation was you didn't need law enforcement certification, and there had not been police involvement, so she would not have been able to get law enforcement certification. I mean,
congratulations on that case.
Yeah, so that's where you have to think about these things carefully, because then the thing about and let's talk a little bit about the U visa situation. The U visa, the advantage there is there's a much wider variety of crimes that you can show that the person was a victim of. I mean, U visa, not only are they your classic sort of violent crimes like abusive sexual contact, domestic violence, false imprisonment, female circumcision, all of that stuff, but it also covers some other things like witness tampering, some things like perjury, obstruction of justice. There are other crimes that are within the purview of the U visa that can qualify for the person for it, but you have to get the law enforcement certification.
Yeah.
So let's talk a little bit. What's your experience been like working with law enforcement? Because each law enforcement agency is going to have a different policy, right? The feds are going to have a sort of internal policy for how they decide whether they're going to cooperate with you on this case. And each local or state law enforcement agency can set its own standards for when it's going to approve or it's going to agree to sign its certification.
What is the question regarding certification? My experience.
What's your experience has been like working with law enforcement, and how do you make contact with law enforcement, and what's expected of you as the attorney, and what's expected from the law enforcement agency?
Sure. This is definitely agency by agency. When you have a U visa case coming into your firm, the first thing that you can do is actually I don't know if it's a SISTA, this would kind of be a follow-up question, or is it CAS? There is a database, an online cloud database of law enforcement agencies and their U visa contacts. So the first thing that I do is access that database, and I'm not remembering the organization's name right off the top of my head, to see if an attorney in the United States has already identified the person to contact in that agency. Okay, because we don't need to reinvent the wheel. We know who to contact. If we don't, my most recent U visa case, we have a small city very close to my law firm. And even though this small city is surrounded by a bunch of other cities that have U visa contacts, this city does not. They may have never even signed one before. They're so small, they don't have a victim services unit or main detective who communicates with victims. So in that scenario, what I did is I wrote a letter. This is where I injected myself, because I'll give a counter example. Okay, so I thought I wrote a 2-page letter because they didn't have a contact, they didn't have a victims unit, they didn't have a lead detective who takes these types of cases. I wrote it straight to the chief of police. We're talking about a small city here, okay? Mm-hmm. 6 or 7 square miles. So I just wrote a letter directly to the chief, who also has an email address online, okay? And I sent it with a copy of the police report that the client obtained. And I wrote a little bit, I mean, it's not just from the police report, but, explaining a little bit about the U visa, very short and succinct. I don't want to bore them or make them feel like, oh, this is a very difficult, complicated process I can't comprehend. And then I also attached the Department of Homeland Security guide on U visas. So cover letter, police report, and I also, I did not, so that was, I sent that out, and a few weeks passed, and I didn't hear anything, so I actually asked my client, hey, can you write a thank you letter to the police for helping you, and urge them to work with your attorney? And she did draft that, but we didn't have to send it because I got a piece of mail with a signed certification. Like
Wow.
they didn't call me up and say, hey, we got your letter, we're gonna sign this. I'm sorry, James, I need to add that to my cover letter. I attached the supplement B.
Okay. All right.
It filled out, I went back and forth in my head, like, oh, I should make contact with them. I should tell them about this, ask them to do it. My partner's like, fill out the supplement B, put a sign here tab on it, highlight it, and just attach it to the letter. So it was actually cover letter, supplement B, police report, and then the DHS guide on certifications.
I think you handled that perfectly because if it's a small office, it's probably going to arrive there. They're going to take it to the either the chief of the police or someone senior who's in charge. You made it very simple for them. You included the DHS guide so they can see what is this, what actually is involved with this. You already filled it out. All they had to do was sort of make a determination that they could do this, they were willing to do this, and sign it and send it back to you.
Yes, and I didn't want to get this is why I didn't want to go through, even if someone told me, because they didn't have this format inside of their agency already. I was worried about getting an RFE in the future that said that whoever signed it wouldn't have the authority. That's why I went straight to the person who has the authority, the director of the whole public safety department, the chief of police. And another reason why I chose to do this letter is because I did go in person before writing this letter and to talk with someone at the front desk, and the information I was gauging from them is that they really don't know anything about U visas. Okay, so I need to go to the top person. That's who I need to speak to. And I can contrast this with another city that's really just, 5 miles down the road from that city, where they did have a detective who handles these types of victims matters, very seasoned, has probably signed U visas before, super easy to just call the police department, ask to be transferred to that person. They're very willing to sign because they've been through this before. They know. Okay. I didn't need to write them a cover letter or follow after them, actually. And I did prepare the supplement B for that seasoned officer, though. I did prepare. They wanted it to be prepared. I will say, as a practice pointer, that I do think we should prepare supplement Bs for the officers. We should be preparing them. Obviously, it doesn't need to be the final version, but they need, we should be preparing what we want to go into the U visa application. And
that's interesting. I think the DHS guide says that it's the designated or supervisory or designated law enforcement official who's supposed to complete the supplement B.
Well, I'm sure it says that, yes.
There's there's definitely something to be said for sending them a draft and doing as much of it as you can for them to make it easier for them.
Yeah, I tell them it's a draft.
Right.
I tell them it's a draft. This is what it's supposed to look like. This is what I would want it to look like. If they want to go and pull up the supplement B and refill out the information. In the supplement B, I also don't stray from the police report, though. I don't add in additional details or facts, or I don't make it. It's not like the client's personal statement. I don't know. This is just I just want to grease the wheels and get it done. If I had left it up to this small city to do this, they would not do it. They're not going to fill out a supplement B. They would get nervous about filling out this form. They might feel like they actually they don't have the resources to guide them to the point to do that. How would you answer some of these questions? Especially the chief of police, who is actually quite far removed from the investigation of the case.
Mm-hmm. Sure.
I don't know if that
no, that's,
do I really seriously deviate from
I always think there's something to be said for making it as easy for them as you can, no matter who you're dealing with. If you're asking them for help with the client's case and it's something that they don't have to do, remember the law enforcement agency does not have to agree to participate. And if it's not something that they've done before, it's much easier for them to say no. So you want to make it as easy as you can. So I think you did that, and I think that's great. In your experience with your clients, so for the U visa, the person has to show that they've been helpful, or they can be helpful to law enforcement in detecting, investigating, or prosecuting the crime. In your experience, during the process, has law enforcement come back to your client to ask them for additional participation, additional information? I guess it's obviously that's totally fact dependent on what the crime was that occurred and how the investigation is going. But is it something that becomes an issue when you're trying to apply for a U visa and the client is still having to deal with law enforcement, or is it more like something that they did at the front end and then they generally don't have to go back for subsequent interviews?
Yeah, it's been stuff that's been done at the front end. The case was investigated, and the police's investigation is closed once it goes over to court. What's interesting is all the U visa cases that I've done that have been investigated by police were prosecuted. Like the suspect was charged with the crime in court, and yet the prosecutors were the most difficult people. I mean, these are my colleagues in the field, a prosecutor. They're a lawyer and I'm a lawyer. Okay, and they were the most difficult people to contact and work with. This might be different in other jurisdictions, of course. It's going to be totally case by case, but it was easier for me. This is counterintuitive to me, but it's easier for me to work with the police through their channel, even though the case went on to be prosecuted. The prosecutors were unwilling to work with me and sign the supplement B. In both cases, prosecutors were considered actually first because there was a case. Cases were going on. Okay, and my clients were active participants as victim witnesses in their own in the trials of the perpetrators of the crime. Okay, and prosecutors, one of them actually just really pushed back and was like, "No, I'm not going to do that," and the other one was just crickets, didn't respond to me at all. I find that kind of odd, being that they are lawyers.
Yeah, not exactly the level of collegiality that you would hope for. Sure. Remember that, everybody. You get what you give. Show collegiality. Extend professional courtesy to colleagues. That's how it's supposed to be.
It's actually the best forum, you would think. Not just the collegiality aspect, but they are representing the victim's interest in prosecuting the crime.
Right.
I have seen victims in the past actually have their own attorneys, not just the defendant. Victims have had to have their own attorneys, especially if there's situations in the facts of the crime that could possibly give rise to culpability. Do you know what I'm saying? There's other situations where a victim wants to lawyer up themselves. It's not uncommon to have a lawyer or a nonprofit or social worker or caseworker communicate on behalf of a victim to the prosecutor. Not uncommon at all. Whereas with the police, actually coming to the police from the perspective of a lawyer could frighten police, because they feel like they need to, it's not prosecuted yet, they need to be kind of this they need to be objective in their investigation, and they don't want to show favoritism working with the lawyer of a victim. I could just see it being opposite of what it has actually, what the reality has been in my practice.
Well, let's go on to some of these nuts and bolts issues with putting together supporting evidence that you need for both the VAWA and the U visa types of cases. In both of these, you're trying to show that your client was harmed. The U visa also has a requirement that the victim suffered significant physical or mental abuse as a result of the criminal activity. In the VAWA, you're trying to show that they were subjected to domestic violence, which is typically battery or extreme cruelty. What are some of the forms of documentary evidence that you consider your bread and butter for these types of cases? And do you, when it comes to working with other professionals like social workers, psychologists, therapists, do you have a sort of list of people that you prefer to work with, or do you leave it up to the client to who they want to see? Do you ever suggest that they see a therapist and be evaluated? And how do you deal with working with these social service professionals?
Okay, so for any typical, like we'll talk about VAWA for a second, but for VAWA cases, any credible evidence standard statement is first and foremost. Personal statement, just like you do a personal statement for asylum. Personal statement is like the first piece of evidence that we submit with their photo identification. With any credible evidence standard, we go very in depth. I would recommend that anybody who's going to work with vulnerable populations, victims of trauma, that they do read up on how to be a trauma-informed attorney before working with these groups. There's a camp of thought of re-traumatizing an individual when you're going through these difficult parts of their life. We are sensitive to that, but in pursuit of advocating for this client, we don't just tell them that this is evidence that's going to support your claim. We do try to empower them, make them feel like because often, like, if you are a victim, you feel like you've lost control to somebody who has controlled you. So in telling this story, you can regain control of your life, and you get to frame your story. You get to tell your story to the government. So first and foremost for them, this is a moment where you get to tell an ultimate authority in the world, the United States government, what happened to you. Okay? And they will read it and they will listen. Okay? This is going to be on record forever. This does usually make my clients feel empowered and feel good working on this, even though it is traumatic for them. But it motivates them to write it down. And I have been shocked at the 20-page statements, like first drafts, like the clients really get with it. It's the first time that I get to tell somebody everything, everything. Because like maybe you would tell a family member, maybe bits and pieces of their story have been shared with a family member or friend over the years. But you'd be surprised, like the tiniest little nuanced abusive things that they'll recall and write down. And it's like getting it off their chest. We edit it. We don't want to be submitting a 20-page statement, but oftentimes my statements for VAWA do exceed 10 pages because I also I want them to tell their story. I truly want them to give a piece of themselves in this filing. There's only been one VAWA case where I recommended seeing a forensic evaluator because they had come in on the visa waiver program. They were married almost immediately and within 2 weeks left the marriage. So because of the facts of the case, I felt that I wanted a little bit more evidence as to the harm, because like there was no police report. There was no arrest. Okay, so the abuse was solely the story. There was no other corroborating evidence. And normally in maybe like a long marriage, for example, I would say, I don't care. I don't need any other evidence. Like, your story's good. This is a very lengthy marriage. You reside together. You have kids. Okay, not for this case. A 2-week abusive, horrifically. I mean, the facts were very similar to your T visa case, and we explored a T visa for this type of case, but she was married to a U.S. citizen, so VAWA it was. And just the 2-week marriage and the visa waiver program said they didn't have to. I'm not forcing my client to do it, but I said it would be, it would support your claim more if we could get you a psychological evaluation. And we hooked her up with a social worker from the University of Michigan to do that. She was willing to do that. She wanted to do that.
There are a number of psychologists and social workers out there who regularly work with people in these types of situations. You can search for them. I used to have a list of people in the region who were trauma focused, who did deal specifically with victims of trauma, and So you want to make sure that you get as specialized assistance as you can, and it's so you actually would suggest the professional to them. That's what I used to do, is actually suggest who to
Yes,
go
I
to
don't say go out and find
and
somebody.
find someone.
No,
Right?
no. I have a small list, and the social worker who did the evaluation for that VAWA client, I did not use for the next U visa client. U visas. There was a domestic violence U visa recently, and that person, we used a different social worker, because when I touch base with the social workers that I work with, I keep an email contact with them. When I have a possible referral, I get on the phone with them, and in that kind of that pre-screen phone call with the social worker who I typically use, there were certain aspects about this client's case that maybe she wasn't so good at contextualizing. Okay, because I need them to understand the context when they are writing their report. And so we found and used a different social worker who did understand the context. And it could be cultural context, right, for the client. Maybe something about their background is unique to domestic violence that an American or Western mind wouldn't understand is abusive, but it would be abusive in the context of that person's culture.
Now, in the situation you were talking about, since the abuse was so significant, did you, and it seems like it occurred recently, did you not, there had been no police involvement, you said, but did you not want to make a suggestion that they actually file a police report at that point, since after they came to see you?
So there's a 911 call. There's a 911 call. There was a 911 call, and what I provided with the initial filing is she had a business card from the detective who she talked to, who wasn't helpful. We included a photocopy of the business card with a hotel card because she met him at a hotel, the police officer. But when we got the RFE, I FOIA'd the 911 call and had her daughter in Europe transcribe because it was like half in a foreign language and half English, and we got it transcribed and submitted it. So that one did not need to be reported. For cases where there are crimes that have been committed, and I mean, this is just a good question in general, because I've had people call me up and say, am I eligible for a U visa? I've been a victim, but they haven't reported it to police. I've had to go through those steps. And
right.
Yeah.
I mean, generally, at that point, they've not yet filed their petition. Going to the police and filing a private criminal complaint is probably a step you want to recommend.
Yes, 100%. There are jurisdictions, though, like the lady who called 911, that actually was not willing to. They didn't care. They didn't want to investigate or open up a case. They saw it as like a private family matter. This was like some small town in Texas.
How about finding proof of the abuser's immigration status? Has that ever been an issue?
Yeah, same case. Actually, same.
How did you approach? How did you solve that? How did you solve that problem?
I ran. Well, I gathered as much. So the first thing that we did was, in her written statement, we actually do subheadings in our written statement to make sure that we are hitting the elements that you need to prove. So one of the subheadings, like right early in the first 2 pages of the statement, are establishing that the spouse is a citizen, and she described in detail the first time that she saw his U.S. passport in his hand. That was the first thing that we did. And then she had told me that he, as an American, had a criminal past. So I went through the various states that I could figure out and ran searches on his name and date of birth, and I found a very robust criminal history in the state of Connecticut, and I ordered those records. Now, this is something you can do in immigration, but you can't do in criminal court, right? Past criminal conduct having probative value for current alleged criminal conduct. And so his name, date of birth, lots of previous assault, domestic violence charges over in Connecticut. And that stated his citizenship on there. I was also able to find on a free website that he was registered to vote. Okay, so you can only
And
use
that was
certificates.
sufficient. So you didn't. So you got this done, and you got this approved without a photocopy of his U.S. passport or a
Yes.
photocopy of his birth
No.
certificate.
No photo. We even stated his country of birth wrong. The client said Albania because the person is like ethnically Albanian, speaks Albanian, but when that citizen, he was an immigrant himself. When he initially came, it was Yugoslavia.
Mm-hmm.
So actually, when I got those criminal reports from Connecticut and it said Yugoslavia, and I was like, oh my gosh, like beating myself up that when I was told Albania, that I didn't kind of like think of the history of that part of Europe and be like, well, was Albania a country back then? But there was no issue with that. I mean, no, I do not have a copy of this person's passport.
Okay. All right. Let me let's talk a little bit about some other sort of nuts and bolts. So let's talk about sort of really attorney things like sort of fee agreements with the client or fee waiver requests that you might be submitting to USCIS. I mean, sometimes clients in these types of situations, when you're dealing with humanitarian situations, I'm not always, but oftentimes, you know, they're in crisis. I mean, they're always in crisis, but resources can be a problem. Do you find that you need to offer payment plans? Do a lot of the clients with these types of cases apply for fee waiver requests?
I stopped doing fee waiver requests probably about 4 years ago.
Okay.
And the reason is just because I'm not a nonprofit and I am a private practice. I would very frankly explain to my clients how much time it would take me to fill out a fee waiver request,
right,
that they'll end up paying the fee to me to do it.
Yeah.
So it's best if we can just muster the fee, because my fees are going to probably exceed that amount over time because they can be very difficult to do, the fee waivers. So I haven't done one in 4 years. When it comes to other types of things, it's just on an ad hoc basis. So one of like a recent U visa case, they had a nonprofit pay my fees to do an I-765B. And through the I-765B is when we explored eligibility for the U visa. So when they were coming off of that kind of help from the nonprofit and transitioning to being responsible for their own fees for the U visa, I did offer to do the certification process pro bono, that part of it. In any other case, someone off the street, I would charge separately to do the police certification before moving forward because you don't know if they're going to certify or not.
Right.
On an ad hoc basis, I will offer pieces of my services pro bono, and so the client understands that. I will like factor that in. And fee, you asked about payment plans.
Mm-hmm.
We do payment plans, but I don't necessarily find them to be super helpful to the client because I will not accept payment after a case is filed. So you have this tension now between I want my case filed and I also want a payment plan. My payment plan is only going to be the duration of the preparation of the case. I do not offer payment plans after filing.
Mm-hmm.
Okay.
Mm-hmm. Do you find that do you ever have to refer people to nonprofits, people coming in with these types of cases, and for, you know, because of the situation that the client's in, the crisis that they're in, they cannot meet your needs they cannot sort of, you know, basically afford you as an attorney, and you have to refer them to a nonprofit. Does that come up?
It does come up. Usually I've never had this happen with a client who signed up for my case where I've had to then say this isn't working out and you need to be referred to a nonprofit. Usually during the consultation phase, that's where people will get screened whether or not they can proceed with a private attorney or if they can't afford it. People who normally when I talk about nonprofits and respect for nonprofits, I respect the work that nonprofits do.
Of course.
Okay. And it is important. But I do try to explain to my clients the difference between working with a nonprofit who is doing your work like for free based off grants they receive versus them receiving my services in exchange for direct payment to me. I'm like individually motivated by their payment, and their payment guarantees space in my own individual brain. Right? It's like it's not them in an organization, and any attorney that might have the position and then or like attorneys rotate in those positions over time. I am your attorney. You paid to have a label in my brain, always there until your case ends, actually. That is real, that's prime real estate in my brain. I will constantly be thinking about you and working on your case. And normally when I explain the differences, they'll say, no, I want you, Chelsea. I want to work with you. They understand the value of the dollars that they're investing in their case.
Okay, wonderful. Okay, good. I mean, that's, sometimes that can be an issue. It's a delicate balance. What other important things do you think should go in your attorney-client agreement that might be of particular interest to people considering taking on humanitarian type cases? Are there provisions that you put in your attorney-client agreement that have to do substantively with their cases, or anything different with the attorney-client agreement that you'd give to a VAWA or a U visa applicant than what you might give to sort of a regular family-based application?
So I'd say in general, all my fee agreements are the same. On a case-by-case basis, I may put something else in there. So for the VAWA and or U visa cases where prior to executing the fee agreement, it was mutually agreed upon between me and the client that they will seek a psych eval. I will put that in there that that the representation is contingent upon them doing that, because I'm only agreeing to be their attorney because without that, maybe my fight I feel is too hard. Okay, so yes, I do have a paragraph in there for some cases about that, spelling out the name of who their social worker is going to be and how much those fees are to a third party vendor, not me. Okay. For the asylum cases, I mean, really for U visa case too, being very clear on what the scope of representation is. Cases have been for so long. So while the scope of representation is detailed in all my fee agreements, just making sure that the client really understands for asylum and U visa, it is more so focused on the case management is different for those cases. Okay, so once something is filed, there's a limited scope of representation filed in the following that involves, I spell it out, what that limited scope then is. It's kind of you go, I'm here, we're prepping every single day, we're working hard on your case. Once it's filed, those cases are going to pen for 5-6+ years. So now we go down a step in terms of the scope of representation that I'm going to check the case processing times for those case types on the schedule that I do in my firm in general, and that I will communicate with the client if any correspondence is received. But it's not going to include follow-up requests or expedite requests or requests for an interview. Those things are more clearly spelled out for those types of long pending cases. So the client and me are eye to eye on what I am going to be doing for the next 6 or 7 years on your case. It's actually really terrifying to say.
Well, those U visa cases now, last time I checked, it was taking something like 5 years to get an adjudication or to be placed in U visa.
To get waitlisted, I think.
Right. And basically at the point at which your case is adjudicated, you're placed in deferred action, and then to actually get granted U status takes even longer.
That I don't know. I mean, I just tell people maybe 10 years.
Right. Definitely not a short road. All right, let's see. Well, Chelsea, we're a little bit over time, but I just want to ask another question. And are there particular organizations for lawyers that are considering taking on some of these practice areas?
Absolutely. AILA. I have been an AILA. I could not be an AILA member when I was at the Department of Justice. And as soon as I got out, I mean, I was very eager. I was jealous, actually, when I was working at Department of Justice. And one of the immigration judges was like, no, you can't be an AILA member. I was like, what? I'm like, but they have so many resources to help you write your decisions. But no, that resource is for the private bar,
right?
Not for the government. But it was, I mean, they offer such amazing resources. I really wanted it then. So it was like my number one to do as soon as I exited government work. And I've been an AILA member ever since. Their offerings have exponentially blown up since I was a young lawyer. I feel like they have everything under the sun. I'm super interested in federal litigation right now. They have a federal litigation section. They're filing class action lawsuits. I mean, the community has always come to bat for me. I not just belong to them as a national member, but my local chapter, and the local chapter has its own kind of private Gmail or Google group that you can email. There's many other nonprofits that I do not subscribe to, but I use their resources online, like ILRC,
Yes, right. Those are the two big ones that I was going to. For those who don't know, ILRC is Immigrant Legal Resource Center. It's ilrc.org, and I
have it on a tab on my Google right now.
There you go. And they also do not only advocacy, but they provide a lot of resources for advocates and community members and practice advisories. It's really a great organization. Same thing with Assista. Assista is for, let me just get their exact mission statement here. So they are for immigrant survivors of violence, doing policy and advocacy, impact mitigation, legal assistance, and training. So those would be, I would say, those would be, along with AILA, your other two big ones to look into. AILA at their national conferences typically has a humanitarian track where they focus on these types of issues. So you want to be spending your time there if this is your ball of wax. The Federal Bar Association from time to time can have excellent programs. Those would be some other suggestions. It's been great. Yeah, what's that?
Facebook.
Yes, and Facebook. And I always plug Nerdy Immigration Lawyers, which is a kind of a funny name, but it's a Facebook group for immigration lawyers. There's thousands of members, and people in general in the immigration law community in general, and in that specific Facebook group, are very open toward sharing their experiences. I mean, if you take on a case and you find yourself in a situation where you're not exactly sure the best way to proceed, you want to just put it out there to the collective mind for ideas and suggestions from colleagues. That's the way to go, is to put it out there in the Facebook group, and people will chime in and maybe bring up things that you hadn't thought of. And it only makes you a better lawyer to do that, to collaborate with your colleagues and share experiences. That's how everyone develops their skills. But anyway, Chelsea, it's been great to speak to you, and I really appreciate your insights. It's been good discussion. We hope to have you back, and for everyone, I hope you've gotten a lot out of this program. We'll have future webinars sponsored by Docketwise, and thanks for your attention, and have a good day all.
Thank you.